Wagwan. Good morning, good night, welcome back. And if you're listening for the first time, I'm your host, Melanie Byfield, welcoming you back to what seems like it's been a minute, to the next episode, 24 of The Real Situation, where we give you a taste of Jamaican politics. Yes, the review of the Constitution Amendment Republic Bill 2024 by the Joint Select Committee, together with the political grandstanding and lecturing, are coming to an end. There was a meeting on May 7, which continued reviewing the submissions made to the committee on Section 49. And there was also a hearing on June 4, which pretty much just reviewed the minutes of the last meeting and announced that the committee's draft report has been circulated to its members. The Road to Republic website has minutes for 6 of the meetings, the 2 presentations, and 14 submissions from the public. So what's going to happen when these meetings are over? A report is going to be prepared by the Joint Select Committee. Here's a quick reminder of the meetings that took place so far. There was January 15, where the opposition leader read a statement basically saying there'll be no further participation until 4 questions are answered by the Prime Minister, to which no formal response has been given. January 22nd was a presentation on the bill, giving an overview of what would be reviewed. January 29 was focused on the parliamentary cabinet system. February 6, citizenship. February 19 was a presentation by the Ministry of National Security, and they also focused on citizenship. February 26 and March 12, the topic there was the Office of the President. March 19, the Parliament and expansion of the Senate. March 26, April 2 and May 7 have basically talked about submissions by the public, and then we have the hearing that took place on June 4, which basically announced that the draft report has been prepared and circulated to the members of the committee. So, major points to take away from that May 7 meeting. The JFJ, Jamaicans for Justice, have proposed amending Section 49 by having the amendments published 30 days in advance of any bill being tabled in Parliament, so that the public can comment on it in advance of any debate. Mona actually also made a recommendation in that respect, which Marlene Malahoo Fort was having none of, and said that the recommendation was not accepted. She basically said, "Hold on, submission from where? No, not 14 days, pound 14 days for nothing." What can go so? Well, apparently Section 1A was giving Ms. Malahoo Fort a problem. So basically, here is what was said. Section 1A recommended campaigning and public education to enhance voter turnout during constitutional referenda. 1 month followed by another month, as opposed to 14 days before amendments take place. That's what's being proposed by Mona, that 1 month period. The Constitution actually says 3 months. Here is what is being proposed in the draft bill, that there be any alteration other than subsections 2 or 3 shall not be submitted for assent to the President unless a period of 14 days has elapsed between the introduction of the bill in the House and commencement of the first debate on the whole of the text of the bill, and a further period of 14 days has elapsed between the conclusion of that debate and passage of the bill by that House. So Jambar also took issue with that proposed amendment, saying that 14-day period is too short and it doesn't give enough consideration for the review recognising the fact that this is the Constitution and it's important. Jambar actually proposes that the period be extended to 1 month also. Ms. Malahoo Ford did add that they'll be considering the submissions more carefully, and the goal is to simplify the mechanism without compromising the rail guards. They ultimately want to take another look at the structure of Section 49 without compromising it. So what's next? Amendment of Section 58 of the Constitution. The Ministry of National Security wishes to highlight that dissent is defined differently under Section 24, subsection 3, in relation to the citizenship qualification for President. Stating for the purposes of paragraph 2A, by dissent means by virtue of having a parent or grandparent who is a citizen of Jamaica by birth. The definition here limits the application to descent to a grandparent. Why was this approach not utilised as the definition throughout the amendment? Ministry of National Security, let it go. Let it go. Malahoo Fort says, simple answer, because the citizenship relates to different things in different sections of the Constitution. That is it. Clause 26, repeal and replacement of Section 60. So, here, when a bill is presented to the Governor-General for assent, he shall signify that he assents or he withholds assent. Right? Now, the proposed amendment is if the President doesn't signify assent within 30 days after a bill is presented for assent under subsection 1, the Speaker shall signify assent. So that's a good, a question I have is, why did the Constitution afford the Governor-General the ability to withhold assent initially, and why is it being proposed that be removed? Senator Sinclair had a few questions regarding this amendment, and Marlene Malahoo Fort basically stated that there was one occasion where the Governor-General did withhold assent and the bill just didn't proceed. Remember them word there. I'm going to come back to that. Now, in the Jamaica Gleaner, September 29, 2024, Mikel Jackson of JFJ is quoted in an article called Powers of President Critical to Successful Referendum. And I'm going to read you a little bit of that article. Ms. Jackson says, the reality is that the President should be utilised as the guardian of the Constitution while respecting parliamentary sovereignty. Our history has taught us that parliamentarians will sometimes act on the basis of political expediency without respect for rule of law or the Constitution. For avoidance of doubt, the President should not have the power to veto bills, but should have the authority to request re-examination of bills. We are reminded by the Minister of Constitutional Affairs that the courts are there to rule on the constitutionality of laws should that come into question, so there's no need for the President's intervention in that respect. However, though the Supreme Court will ultimately rule on the constitutionality of any law, a person is needed to approach the courts for such declaration, as the court cannot intervene on its own. If the parliamentary opposition falters in its constitutional role as an effective check against an executive, whether it be due to dereliction of duty by Westminster parliamentary design or not having the money to challenge a questionable law, it leaves an under-resourced civil society to find those funds to mount a legal challenge. Never mind that we must also prove legal standing to even have the matter heard to begin with. Therefore, the President, while respecting parliamentary sovereignty as the elected voice of the people, can and should be seen as a source of checks and balances against elected politicians. a bill is an act of Parliament in its draft stage, basically, right? It cannot become law until it's approved by both houses of Parliament and receives the formal royal assent of the Governor-General. So there's obviously issues with that proposal there, right? There is the question then, does Sir Patrick Allen have the power to refuse royal assent, following advice from the Cabinet that is headed by the Prime Minister? In an interview with Hour Today on August 2, 2023, Lloyd Barnett, well-known constitutional attorney and member of the Constitutional Reform Committee, basically said that the Governor-General cannot withhold his assent. He says legally he's not given any right to withhold assent. Once the bill is placed before him, he has no discretion. Once it comes from the Parliament, he can't legislate and say, I'm not signing it. It's an automatic thing, he stated. Since the appointment of the first Governor-General of Jamaica, Sir Kenneth William Blackburn, in 1907, all bills brought to the Governor-General have received royal assent. There is no Governor-General in the history of Jamaica who's refused to give his stamp of approval. So then, going back to the statement by Marlene Malahoo Fort, which was that there was actually one occasion where the Governor-General withheld assent and nothing happened with the bill. I wonder if that was before 1907, because according to Lloyd Barnett, it no gosa, never has. So that would be interesting to know. All right, moving on to clause 27, which is the amendment of section 64. There's a recommendation from Equality for All Foundation, which says we object to any proposal that expands the grounds on which Parliament can be extended. Marlene Malahoo Ford says blah-de-blah-de-blah COVID. And so it's important that everyone understand that there's a difference between a public emergency and a public disaster. She goes on to say, it makes no sense that things are reasonably foreseeable and we don't plan for them. This is not about trying to hold over power or anything like that. It's recognizing that things can happen, and when they do happen, we have to respond to them. So what is the definition of a public disaster anyway? So it is a catastrophe or emergency, actual or imminent, of such unusual proportions or extent that, number one, a substantial number of residents either sustain injury, become ill, or are infected with disease, have their lives imperiled, are killed, or die as a result of injury, disease, or exposure. Or two, that property of a substantial number of residents is imperiled, damaged, or destroyed. And it is necessary and essential in the interest of public safety, health and welfare that the continuity of the government be assured in order that it's enabled to function properly and efficiently and to exercise its essential powers in meeting emergency conditions. And it's given an example of like earthquake, flood, tidal wave, riots, insurrections. Now, Jamaica's been there and done that, right? And has actually extended the life of the Parliament. When did that happen? Well, Hurricane Gilbert in 1988 was the most destructive storm in the history of Jamaica. It hit Jamaica as a Category 5. There was 318 deaths from Gilbert, 45 of them in Jamaica. There was 318 in the Caribbean, who died. 45 of those deaths were in Jamaica. It caused $2.98 billion in damage. Edward Seaga, who was Prime Minister at the time, held an election in 1989, which he lost to Michael Manley. Now, the Parliament was extended due to Gilbert. Seaga took office in December of 1983, but the election wasn't held until February of 1989, so that was more than 5 years later. So the question is, why is it necessary to add to this and enshrine it in the Constitution when it was a common sense action that took place already? So what does Jambar say about it? Jambar says, we have no objection to this amendment, as we believe it's appropriate to extend Parliament's duration during a public disaster to ensure continued governance in the interest of public safety. Additionally, we support retaining the constitutional safeguard that limits any extension to a maximum of 2 years. This measurement is important to prevent potential abuse of power by any government. I'm actually in agreement with Equality for All Foundation on this one. There should be no expansion of those grounds for Parliament to be extended. And who agrees with us as well? PJ Andrews. Moving on to Section 67, which is the new Part 5, the Electoral Commission of Jamaica. Equality for All Foundation welcomes the enshrinement into the Constitution. Jamaicans for Justice also made a recommendation saying that to safeguard the independence of the ECJ in its powers and performance of its functions, the Commission should not be subject to the direction or control of any person or authority other than the Supreme Court by way of judicial review. A couple of other comments from this meeting. Jambar confirmed that there is actually no need to vest the intellectual property of the symbols in the Constitution, that there are existing laws that amply protect the national emblems against their misuse. Rastafarian Unity Council want to change words in the national anthem. Give us vision lest we perish. They want to change the words to give us vision, let us prosper. Let me know what you think about that. Not feeling it personally. I think not feeling it personally, but let me know what you think. And then another recommendation by the Unity Council was to change the national fruit from ackee to mango. I, again, personally wouldn't agree with that recommendation, and here's why. So the reason why they believe that ackee should be changed is because of its high content of arsenic. Now, we all know if you leave ackee alone and make it just open by itself, everything is fine, and that toxicity is released when it opens by itself, right? So if that's the reason, then we all know what prevents that toxicity. Ackee actually originates from West Africa. So, back in when there was slavery and Africans were forcibly brought to Jamaica from Africa, ackee would have been brought to Jamaica in that way, right? Mango originates from India. I ate that. All right. Senator Shireen Golden Campbell had asked for a list of all submissions to the committee. So to wrap up what happened on May 7, who submitted in total to the committee? It was the Akompong Maroons, the Church of Haile Selassie, Equality for All Foundation Jamaica Limited, the Faculty of Law, UEMONA, the Jamaican Bar Association, the Jamaica Coalition for a Healthy Society, Jamaica Lands, Lands being an acronym for Left Alliance for National Democracy and Socialism, the Jamaican Hummingbird Taino people, Jamaicans for Justice, the Ministry of National Security, Christopher Hinge, Hugh Dunbar, O'Shane Wright, Helene Wilkinson, the Rastafarian Ainity Council, the Rastafarian Mansions and Organisations, the West Indian Tribal Society. And just to briefly touch on the June 4 meeting, it basically just confirmed that the draft report has been circulated. It was circulated to members on June the 3rd. Policy issues now have to be addressed by the ministries with portfolio responsibilities and then sent back to the Cabinet for the matters to be settled. So at the next meeting, which has not been announced, the draft report will be discussed. So much trouble in the world of Jamaican politics. Yes, there is so much trouble between Dennis Chung's controversial appointment, the governing party's proposed removal of the Auditor General from the Integrity Committee, the alleged corruption surrounding the purchase of a multi-million-dollar drill in the healthcare industry, and fake news, not oil Nadea, but all a little bit. There is a company who gave an interview who are drilling oil and I beg investment money. So, as I said, there's so much trouble. Speaking of Dennis Chung, there was a fantastic interview with Donovan Wignall. He is past president of MSME Alliance, and Danielle Archer, who's the principal director of NIA, National Integrity Action. It was on CEEN, CEEN TV, and the show was called The Conversation. Kwame, can't find your last name, but he hosted it. And the topic of the show was called Governance Under Fire. And it was really talking about Dennis Chung's FID appointment. So here's some questions that Danielle Archer had, and that we should ask ourselves. Did the PSC process work? There was a vacancy, an application. What was advertised? Why and when was the communication changed? Originally, 12 years in law enforcement experience, 5 of which should be at a senior level, was the requirement. But that was actually removed from the job description for Chief Technical Director of the Financial Investigations Division late last year. So, Ms. Archer went on to say, that it's really, we should ask ourselves if it's what is most appropriate, right, is whether the PSC made the right selection. And what was the procedure leading to the selection? Was it correct? There's also a concern whether the investigation into the Prime Minister will now be transparent and fair. And should Mr. Chung come back and say, well, I've done the work, here's my report, here's my findings, and it vindicates the Prime Minister, how many of us are going to accept that report? I mean, he's in a very difficult position. Donovan Wignall compared it to a jury selection, right? Choosing a jury to adjudicate on a case with the Prime Minister. Would Dennis Chung be a suitable juror? And if no, it would probably be his public announcements that are making these optics not look good. So what exactly did Dennis say? It was in relation to these 28 bank accounts that the Prime Minister is alleged to have, right? And Dennis says, in fact, I can tell you my experience, and I'm quoting Dennis Chung here. In fact, I can tell you my experience is that if you go into several private sector businesses, you're going to find that they have a multitude of bank accounts, some of them inactive, some of them they are using, but people open bank accounts for specific purposes. So it's not unusual for people to do multiple activities. If you're doing multiple activities, then I find that one of the ways that people, especially non-accountants, try to reconcile their business is by having payments through different cash bank accounts. He goes on to say, so I heard this story about the number of bank accounts that are out there, and the truth is that it's really detracting from what the real substance of the argument should be, which is, what is it that is going through the bank accounts and how much money is there? Because if I have 28 bank accounts, for example, I could have 2 million between them. Someone could have 2 bank accounts and have 500 million. So the greater problem there, the greater problem than my 28. So that is a greater problem than my 28. So I don't think that the number of bank accounts is something we should really focus on, because it really has no substance behind it. And he goes on to say that, some institutions might actually mandate that you have an additional account for a different product. Now, it's alleged in an article by the opposition leader, and I'm going to quote here, that he, the Prime Minister, operated no less than 28 bank accounts. His 3 personal companies were involved in a very high volume of transactions, averaging more than 4 per banking day over the period of review, including many substantial intercompany payments and including more than 4.5 million of cardless cash deposits made over a 3-month period into his bank accounts by depositors whose identities remain unknown to the Commission. So, again, the question is, does this appointment strengthen the political view that there is, in fact, commitment to anti-corruption and ensuring parliamentarians will be investigated for illicit enrichment? As a reminder, Jamaica loses approximately 100 billion Jamaican dollars every year to corruption. That's about 526 million US dollars. So, another question. What does all of this trouble have to do with Jamaica's journey of constitutional reform, and how can it be addressed? We go back to that critical word that you've heard a multitude of times during this podcast, and that is governance. Kwame Nkrumah, the first president of Ghana, said, "Seek ye first the political kingdom, and all else shall be added unto you." If the political system is developed first, it can serve as the instrument through which social and economic development is achieved. But of course, if the wrong choices are made about the political system, it can inhibit change and development. So that word governance, we are going to finish up here with the words of someone who speaks with great authority with regards to governance in Jamaica, and that is Professor Rosalie Hamilton. She was reasoning with Rattigan on his podcast on May 1, 2025, and reminded us of 2 things. 2 main things the Constitution does. It protects and establishes our rights and freedoms. And of course that is enforced by the Charter of 2011, which amended the Constitution. And also it defines and describes the structure of government and the governance arrangement that we have. But we haven't fundamentally done this. Professor Hamilton goes on to say that to move the king as the head of state to a local president is a significant change, but we argue that that's not enough, that when you shift the head alone, you don't change the structure. We need a constitution that gives every Jamaican a fair shot at living well, lifting their standards of living and developing their communities. We need to create the type of constitution that we want based on our history. Professor Hamilton has actually given a new direction to this discussion on constitutional reform. And I'm going to wrap up with a statement regarding this constitutional reform by Professor Hamilton. Perhaps Professor Hamilton goes on to say, on December 10, 2024, the Constitution Amendment Republic Bill 2024 was tabled in Parliament. We commend the government of Jamaica in taking this step forward, Jamaicanizing our constitution, abolishing the British monarch as head of state and establishing the Republic of Jamaica. While there is agreement with some aspects of the bill aligned to these objectives, the Advocates Network, Jamaica Council of Churches, Institute of Law and Economics, JABEM, Jamaica Beach Birthright Environmental Movement, among other civil society organisations and individuals, share concerns about some troubling aspects of the bill. The major flaw in the bill is seen as the retention of the parliamentary cabinet system of government without significant changes to its original design in the 1962 Constitution. By retaining Jamaica's expression of this system of government, the bill perpetuates the concentration of the cabinet prime ministerial power, authoritarian leadership, inadequate mechanisms for public participation, and a colonial judicial system. We argue that these weaknesses contribute to poor governance and our inability to address the economic, social, and environmental challenges that we face. We propose the following core changes. Number one, restructure Parliament, mainly by enhancing oversight of the executive, enhance mechanisms to strengthen the voice of the people, to foster inclusive governance, and democratize the Senate and strengthen its role in government and development. Number two, empower communities, especially by specifying their rights in the Constitution, and further reform local government to support empowered communities, so to foster and support sustainable community development. And number three, decolonize the judiciary and strengthen its independence. These changes aim to improve governance, foster socio-economic development, and ensure equitable access to opportunities across Jamaica. We therefore recommend that the bill should be withdrawn in light of the adequate process of we therefore recommend that, number one, the bill should be withdrawn in light of the inadequate process of public engagement prior to tabling the bill in Parliament. And number two, a well-funded process of open public engagement and education should be pursued for at least a year, and that considers the major flaws in the current structure of our government and ensures the inclusion of communities across Jamaica. Professor Hamilton goes on to say our voices are important in changing the Constitution. We want a government by the people, for the people, and of the people. After all, I feel we're a republic. I am actually going to attach a link to the podcast page which gives you the ability to add your name and submit that you make a submission to Parliament. You are actually in support of this direction for the Constitution, and it has my support. Okay, so I'm actually going to wrap up with some words from Danielle Archer, going back to that interview on the conversation, when she was asked about whether we really need to hold politicians accountable. And here is her response. What if we are actually afraid to hold them accountable because we would have to hold ourselves accountable? Over 90% of Jamaicans believe that corruption is a way of life. Nepotism, cronyism. Some people feel, how we start to change is for us to ask ourselves, are we satisfied with what is happening? And am I prepared to make that change? Have we now accepted that we are part of the problem and we are willing to be the change? And if we are willing to be the change, we can't limit ourselves to how we are going to change it. We have to start changing it in our spaces. Politicians come from us. If you accept they come from us and represent us, it must be that they're talking about the things and elements and values that we hold true. If they're not holding true to our values, why are we supporting them? Just a reminder, if you're not registered to vote, the deadline to register for the next voters list is November 30. The deadline to register is September 30 for the November 30 voters list. I hope you're continuing to enjoy this journey, finding it educational and useful and ting. As I said, there's another Joint Select Committee meeting coming where there will be a review of the draft report. So our travels on the road to Jamaica becoming a republic continue. As I said before, this road can't be patched. It needs to be totally torn up and laid down proper with drainage and all of them thing there, right? Because this needs to last a long, long time. It's 2025 and there is no doubt the majority of Jamaicans don't want to retain an English king as head of state. So for that reason, and many, many, many more, I'm still confident this journey will end with Jamaica becoming a republic, truly independent and sovereign Jamaica, land we love. You can find this podcast on YouTube, Buzzsprout, Spotify, Podcast Index, Deezer, Podcast Addict, Apple, iHeartRadio and Amazon Music. And if you want to reason about anything, or if you can't find any of the material I was talking about, feel free to email me on atasteofja@outlook.com. So until the next time, thank you for supporting this podcast. Please subscribe, like, follow, and share it with friends and family. And again, I thank you for taking the time to listen. One love. Yes, the word is love.